session.
Thank you, Mr. Hivner, and on behalf of Judge McBrayer and Judge Golden, we welcome counsel to this oral argument, which is being live streamed for public viewing. We will conduct the hearing in the same manner as if we were all together in the courtroom. Each of you have 15 minutes for your argument, and the appellant has been afforded the opportunity to reserve some of his time, and he has. Unless there are any announcements, I'll ask Mr. Hivner to call the case.
Ronald Mercer versus Brandi Chiarella.
Mr. McClendon.
Thank you, Your Honor. Dana McClendon on behalf of the appellant Brandi Chiarella. I'll just briefly cover the facts that are relevant. Ms. Chiarella and the respondent, Mr. Mercer, were never married. They have a child, Cameron, who was born in June of 2012. So he's right about 13 now. The parties have been back and forth to court in Williamson County some number of times, basically almost always about custody and child support. We are here today on the most recent petition by Mr. Mercer to reduce his child support. Judge Binkley, after a hearing on this case, did reduce Mr. Mercer's child support, and it is my position respectfully that Judge Binkley got that wrong for a few reasons. Mr. Mercer, in this case, in a nutshell, presented evidence that his income in this now was the residue of investments that he had made when he was earning a significant amount of money as a professional basketball player. And his accountant came in and testified that his investments were now paying off, but that his income was dropping because he was essentially receiving more of his own principal back than income, as had been true in years past. At the end of the trial, Judge Binkley reduced his child support, finding that Mr. Mercer's income had in fact dropped enough to trigger the 15% or more significant variance threshold, and that is what we appeal from. Specifically, Judge Binkley found that father's income for purposes of child support was $154,305 a year, and found that mother's income, which is undisputed, was $10,116 a month. As I said, the Mr. Mercer's, I'll call her the star witness, was his CPA, and her testimony was that Mr. Mercer's income now is what is being paid back to him with his own principal from investments that unfortunately were not well developed in the record. It is apparent from the testimony that in years past, Mr. Mercer was receiving less of his own principal and more income than he is now. Now that begs the question of, at what point will Mr. Mercer have zero income? But for the purposes of this appeal, Mr. Mercer's income found by Judge Binkley was only that portion of his cash inflow that reflected his income as opposed to his return on investment. We do not dispute that that was an accurate way to look at that portion of this puzzle. The problem, from my perspective, comes up in that Mr. Mercer's lifestyle is one in which he spends about $325,000 a year. That's clear in the record. So he apparently is spending not only all of his income, but substantially all of the principal that is being returned to him every year. And the evidence in the record was that Mr. Mercer has done little or nothing to work since for all period of time that was relevant to this record. The only evidence of any income from effort, present effort in this record, was that he had coached a basketball camp and made about $1,500 one year, I think. And then another year that's in the record, he had made about $2,500 in what were labeled appearance fees.
So do we know for sure then that all income other than the, well, I guess one-time appearance fee 2 years ago, or appearance fees 2 years ago, and then the camp this past year was all passive. We know for sure that's passive.
Yes.
Okay.
I don't think there's any dispute about that fact. It is my position, with all due respect to Judge Binkley and to Mr. Mercer and his counsel, that Mr. Mercer owes his son a better effort than that. Now,
Mr. McClendon, my was the question? I assume you're alluding to your first issue of Mr. Mercer being voluntarily underemployed. But was that issue? Did you raise that at the trial court?
well, I anticipated this question, Your Honor, and
I have the same question about all your issues.
Very well, Your Honor.
All three issues. I can't find anywhere that you raised any of these issues at the trial court that you've raised on appeal.
I anticipated that question, Your Honor. I was not the trial counsel in this matter, and I will attempt to balance carefully my duty of candor to this tribunal, as well as being respectful to the lawyer who did try this case on behalf of Ms. Chiarella. And I will say that when I was retained to appeal the case, I assumed what I would say would be a more robust and thorough record than I in fact got, having dealt with trial counsel as opposing counsel for something on approaching 30 years. The answer to your question, Your Honor, is no. Trial counsel did not develop a record that included the argument of voluntary underemployment, and worse, stated that that was not an argument that they were making at the time. It is my position, respectfully, and I know that Mr. Holloway will take issue with this, but that the issue was not waived because, as a matter of public policy, in a child support case, the obligor, both parents owe the child their best effort. And in this case, it's very clear that Mr. Mercer has done little or nothing in the present day to earn an income. And it wouldn't have taken much, and probably not even the full imputed amount of income that the child support guidelines call for, to either deny a significant variance or otherwise impact the final result here.
Well, I mean, I know you have good intentions, Mr. McClendon, but all of these issues that you've raised, if they haven't been raised at the trial court, we're a court of error. We've got to decide a case based on whether the trial court committed error. And if all of the issues that you've raised on appeal haven't been raised in the trial court, how are we to address this case?
Well, I do think that the issue of return of a reasonable return of investment was raised. I would have to acknowledge in all candor that the issue of a return of investment, which is one of the issues I've raised, was not particularly well developed. But we do know for
is there any citation to the record where that was raised?
I believe in my brief, Your Honor, you'll find that the at least the issue was raised. As I acknowledged, the issue of imputed income for the purposes of voluntary underemployment was addressed and unfortunately waived or not argued by trial counsel. But the return on a reasonable return on capital was raised, although there was not.
Was there any evidence submitted on that issue?
No.
All right.
Well, I think the answer to that is there was. It was just 6 or 7 years ago, which
Correct.
sort of agree with the trial judge's comment on that. I mean, how do you know based on history 6 or 7 years ago what's a reasonable rate of return? I mean, it's going to change depending on the environment, and you need something a little more, more recent than that.
I agree, which is well, I'm left with not much option but to agree. As I said, it is my position with respect to Judge Binkley and this court that when the facts are very clear that Mr. Mercer has done nothing to earn any income by way of going to work in the present, that he owes his son a better effort than that, particularly when he is spending $325,000 a year to have his pool maintained and pay his credit card bills. He took his child's mother to court and obtained a reduction in his child support obligation. And I think that flies in the face of the stated purpose of the child support guidelines, and in particular, the imputed income and voluntary underemployment analysis in the law. Given that I don't have enough time at this point to flesh out my other arguments, I will respectfully defer to Mr. Holloway.
Thank you, Mr. McClendon. We'll now hear from Mr. Holloway. Be sure to unmute Mr. Holloway.
That was the last thing I thought before I joined, and of course I forgot to do it. Thank you. May it please the court. Will Holloway of the Williams County Bar on behalf of Mr. Mercer. Obviously, a large part of our brief addresses the points the court has made today with regards to these issues not being raised at the trial level. I won't belabor that point anymore, but I would like to briefly hit on some of the items that Mr. McClendon talked about, and also some of the items, just so the court's aware as it continues its deliberations over this case, that Mother brings up in her brief. Mr. Mercer was, unlike a lot of professional athletes, smart with his money. That is paying off for him. He made certain loans to certain business enterprises during his professional career, and now those loans are paying back to him. And the loans, as was developed by Mr. Mercer's CPA in her testimony, the loans are on an amortization schedule just like a mortgage would be, in which over time, the interest on those loans steadily decreases while the principal repayment steadily increases. There's no argument that I don't believe from Mother that the principal is not income by definition for the child under the child support guidelines. The interest most certainly is, as everybody agrees. And so a large part of the trial was really spent by Mr. Mercer's expert witness's CPA in breaking that down and showing what portion was interest versus what portion was principal. The interest is on those loans makes up approximately 97% of Mr. Mercer's income today. The income he received from coaching a basketball camp is included in his income, makes up approximately $1,500, and then he received some dividends as well that pay out that was also included. But 97% of his income comes from those loans he has made throughout the years. The possible ways that a court under the Tennessee Child Support Guidelines and under applicable law, the court can impute income, there are three. Mother's brief really touches on all of them. And I will skip over the she didn't raise it in the record argument because the court is obviously well aware of that, and we quoted it in our brief. But the three ways a court can do it, the trial court can do it, are to find somebody who's willfully or voluntarily underemployed, as Mr. McClendon acknowledged, and as was acknowledged in Mother's trial counsel's closing argument. They did not raise that issue. The first time it came up, there was no evidence presented on it. The first time it came up was during closing argument, in which the trial judge asked Mother's lawyer, is there any evidence in the record to support a finding of being voluntarily underemployed? In which case, Mother's lawyer responded, no. The trial court followed up and said, well, did you allege it in a pleading even? And Mother's lawyer said, no. So that issue, there wasn't really an opportunity really to discuss it from Mr. Mercer's perspective. The record doesn't contain any evidence with regards to the factors of being willfully or voluntarily underemployed, because nobody ever raised the issue. And that touches on Mr. McClendon's argument that he's made here today about Mr. Mercer owes his son better. Well, there was no evidence presented about what Mr. Mercer has done for his son. There was no evidence about all the efforts he makes to support his son outside of his regular child support obligation. So Mr. Mercer never did have his day in court to address that issue. So that is another one that is being raised on appeal for the first time. The argument in the brief, Mother's brief, with regards to being voluntarily underemployed, asked the court to assume that a professional basketball coach can, as a matter of law, become a professional basketball player can, as a matter of law, become a professional basketball coach. There's no evidence in the record to support anything with regards to Mr. Mercer making a career as a basketball coach, other than he played in the NBA and he coached a summer camp for kids and earned approximately $1,500 doing that. Those are the sole facts that support the argument that he could be a professional basketball coach. The second path that a party can travel under and to get a court to impute income is by arguing that no reliable evidence of income was presented at the trial. Mr. Mercer presented his CPA, who presented his 1099s, who testified as an expert witness without objection from mother, and who broke down Mr. Mercer's income by category. All of this is which is included in the record to break down this income. And so I would submit, and the trial judge found that it was reliable evidence and that Mr. Mercer carried his burden in showing what his income was. The third category is something that Mr. McClendon did touch on in his argument. That category allows the court to impute income when a party owns substantial non-income producing assets. There was no testimony about Mr. Mercer's cars or the value of his house or any of those things. There was no testimony about Mr. Mercer's assets. Mother's brief on appeal says, well, we do know that he was receiving principal back on these loans that he is turning around and living off of. And mother argues that that can be used to impute income to Mr. Mercer. But that is a circular argument because Mr. Mercer's principal is not a non-income producing asset. It is the asset that he used to produce 97% of the income he makes today. So it doesn't fit into that category. It is not non-income producing. It absolutely produces income. It's producing $150,000 a year in income. So again, that argument I submit must fail because it produces income and doesn't fit into the category. The final argument from mother says that the trial court erred with regards to failing to average 2 years of income to father as opposed to just taking 2019's income. Mother relied on a case to support that proposition. And if the court, as it's looking into that case, it was the Moss v. Moss case that mother cites in her brief. Mr. Moss in that case was a farmer. His income did what farmers' income did, and it goes up and down through the years. At the time of trial, Mr. Moss's income, Mr. Moss's farm was experiencing a drought, and his income had dropped substantially. And so the trial judge said, you know what, this is fluctuating, this is variable, it goes up and down, and I'm gonna average the income. And that trial judge was affirmed on appeal by this court for doing that. The case I cited, and this stands for the same proposition as the Moss case, the case I cited was the Price case. And what Price makes clear is that when income fluctuates, moves in both directions, it is appropriate to average the income. Now, it leaves it in the discretion of the trial court, but when it can go up and down year over year, it's appropriate to average that income. But the Price case continues to say this is quote, it would not be appropriate where a spouse's income is steadily declining or increases. In those circumstances, the obligor parent's child support should be based on his or her current salary. Well, Mr. Mercer's income decreases, nothing substantial, nothing major here, but it decreases based on that amortization schedule. That's the very definition of a steady decline as it relates to his income. So the current case law supports the position that it shouldn't be averaged. And that's not even making the argument that nobody raised this issue at the trial level. That's just based on current case law. The trial judge was correct in refusing to average that income. The final argument that mother makes on her appeal concerns the award of attorney's fees to father at trial. I would simply point out that, again, this is discretionary. All of these issues I submit are under an abuse of discretion standard for the trial judge. Father prevailed on his petition, but there's also something worth mentioning with regards to mother's counter petition. The trial judge said mother's counter petition and the evidence she presented was, quote, scant at best. with regards to what she presented. Father's trial counsel did in my opinion, a good job of cross-examining her to show that a lot of the expenses she was claiming with regards to extracurricular activities for the minor child, she wasn't actually incurring, and admitted that on cross-examination. And so I would just ask the court to consider that as well as it relates to the award of attorney's fees at trial. And then finally, we are asking for our attorney's fees on appeal. I understand Mr. McClendon was not the trial lawyer, and he has to appeal based on the record he has, but at the same time, none of these issues, as have been acknowledged, were raised, and we submit Mr. Mercer's entitled to an award of fees under 365103C. And I've got 5 minutes left, but unless there are any questions for me, I will waive the remainder of my time.
All right, now hearing none, thank you, Mr. Holloway. Mr. McClendon, your rebuttal.
I'll make it as succinct as I can. Here's what you have in this case. You have a retired professional basketball player who's spending $325,000 a year. That's undisputed. I respectfully disagree with Mr. Holloway about his argument about my argument being circular. It's correct that Mr. Mercer's investments have generated income. That's undisputed. But once he has been repaid his principal, he then has a valuable non-income producing asset back in his hands. He has chosen for several years now to simply spend it rather than reinvest it and cause it to generate still further income. So it's not circular, not once he has the principal back in his hands. And as a matter of public policy, and I'm not going to try to sugarcoat it, as indirect or poor as this record may be, this court has the untenable position of telling Mr. Mercer, if you affirm this order, that he can do nothing, make no effort to generate income, and he will return to court with his amortization schedule in another year or two. He will then be making less income. We know this because this has been the history of this case. And this court, or the trial court, will then again be presented with, if nothing else happens, a man who makes still less and who presumably spends the same. And that's a terrible public policy to endorse on behalf of a man who makes a man who spends $325,000 a year.
Well, let me ask you this: do you not think that if perhaps these issues had been raised at the trial level, I mean, you make a pretty good argument. If they'd been raised at the trial level, might the trial judge have found differently?
I suppose that's possible. And
are you foreclosed from doing that now?
I don't think as a matter of law, I'm foreclosed from doing it. I would acknowledge that it is not, that this court would, it is not foreclosed. It may be uncommon. But I think when you are dealing with an issue of public policy, where a man came to court and got out from under the obligation to support his child to the best of his ability, and I don't think there's any dispute that the evidence in the case is that Mr. Mercer's only income, in spite of the fact that he appears to, and I did not argue, with all due respect to Mr. Holloway, that Mr. Mercer obviously could become a full-time basketball coach. What I said, or at least meant to say, was that we know that Mr. Mercer can go earn money because he did. He just chose to do it only a little bit. Whether he chose the imputed income guidelines don't require that the court find that you could have done it and done it this way. They only say that that the court can say, I'm going to impute income because you've done little or nothing. And in this case, there's no question that Mr. Mercer makes little or no effort to earn any money now. And I would point out that in the record, it is clear that Mr. Mercer's lifestyle is extravagant, and that is a factor upon which a court can conclude that a person is voluntarily underemployed or that the income should be imputed. And Mr. Mercer's, the record in this case does include tens of thousands of dollars spent every year at Governor's Club, landscaping, pool cleaning, and so on. So Mr. Mercer is living very well and returns to court periodically with his CPA and says, my investments are paying me less income. Please make me pay less child support. And this court has the untenable position of being in a position to confirm that Mr. Mercer can do nothing today and return to court tomorrow and get yet another reduction. And I don't think that's the way the child support guidelines contemplate a parent's efforts on behalf of their child. Mr. Mercer's attorney's fee award was half of what he spends in a month. It is 150% of what my client earns by working every month. $15,000 to Mr. Mercer is almost nothing given his lifestyle. $15,000 is 6 or 7 weeks of work for my client. And I ask the court respectfully, if nothing else, you can and you should relieve her of that burden. Thank you.
Thank you, Mr. McClendon and Mr. Holloway, for your arguments. We'll take this matter under advisement. Mr. Hibner.